was saying.
Indeed, my lord.
The passage from the joint experts memorandum, which Mr Cox showed us at supplemental tab 21, page 166, on its face is Professor Alibrandi saying that the Italian court would qualify the payments made by the banks to Bear Stearns as upfront payments. And I thought you said, when you were giving us your reply on ground 2, that there was a passage at day 896 in which she either qualified or resolved from that, and if that's your submission, I think perhaps we better see it. It's not in our existing bundles, is it? No, all right, well that's just, it's just a request to see.
That's right. And she said, just to be absolutely clear,
you said she admitted it was formally not an upfront.
Exactly. She said, from a quote formal perspective, close quotes, whatever that means.
So if you could provide that, that would be helpful.
Well, of course, that may be what the judge had in mind when he looked at it, as it were, from an economic perspective, because you can understand the point. If you're just looking at it from an economic perspective, you could say, well, really, what's going on here is, they could have structured it on the basis that Venice made a request to the banks to step in, and the banks somehow acted as their agents in some way, and that sort of analysis. Economically, you could say, well, what was achieved was the same, but it doesn't follow from that. But that's the right legal analysis.
Correct.
And
right.
I think that was the point you were making. Really.
That's right. And if, my lord, just to finish this point, as my lord Justice Mayles has raised it, if you go back to paragraph 261 of the judgment.
Yeah.
If your lordship has in mind that the experts agreed that Article 1196 was a payment from one party to another to rebalance a transaction, so that's the legal test. And what you see the judge...
Sorry, where are we?
261 of the judgment, page 259 of the bundle.
Yeah, and which subparagraph?
I'm just going to start with subparagraph 1, is that what you see with the judge is him trying to rationalise it and saying Cattolica decides that the risk is sufficient, the last sentence, and he then says the rationale is equally is a little too applicable, so he seeks to apply by analogy, and he does that even though he recognises that one of the two elements is not present on this his view. There was no rebalancing, one of the two elements. But he seems to ignore that and then go on to accept my learned friend's argument that it doesn't matter either, that the upfront payment wasn't a payment from one to the other. But he doesn't rely on Professor Alibrandi, but seeks to rely on Professor Gentili, and I've shown you that that evidence isn't actually supporting the point.
Mr Cox actually glossed over that yesterday, didn't go back to that, and didn't challenge your analysis, which seems to me to be right.
That's right.
Professor Gentili, at least Professor Gentili's answer was all predicated upon the bank acting as an agent.
That's right. And so what you see is that the judge clearly has fallen into error here, and it's not supported, I would suggest to you, on his own reasoning by anything Professor Alibrandi did or did not say. And we suggest it is not actually the true construction of Article 1196, because the two elements are very clear. It's not consistent with the novation confirmation, which he does not engage with. And little 3 doesn't engage with that at all. And in fact, having accepted there was no rebalancing, it should have been the end of the matter at 2612 before you even got to the point at 2613. But in any case, even if, as I said to you in opening, even if I'm wrong on all of that, the reality is that you still have to find that the upfronts were paid for the purposes of financing investment. It's the second limb. So even if you find that the payment was an upfront, you then have to find it was for an impermissible purpose. And that stands or falls with
Well, that's your
round
point.
one. My learned friend didn't engage with that, and indeed, as I say, his own expert appeared to accept that a hedging transaction would not be impermissible.
No.
So it matters not in a way, if you're right, if I'm right on ground one, it matters not whether or not this is or is not an upfront, although I say it is not, because at the end of the day, it's not paid for an impermissible purpose, and therefore it's not in breach of Article 1196.
Sorry, and as to impermissible purpose, you said the judge went wrong at 268, I think.
I think that's right, my lord, yes. Sorry, my lady, yes. And I gave you the reference to the expert evidence of Professor Domoncelli as well, which was for the your reference supplemental tab
65.
65.
you said.
So that then takes me very briefly to ground 4, which I can take quite shortly. Lynch and Adams are concerned with legislation. I said that in opening. I don't shy away from that. But they are relevant for precisely the reason my Lord the Chancellor identified, because they concern the discharge of a contract or financial obligations or obligations governed by English law, property governed by English law. And we say that it is clear, for all the reasons I gave you in opening, that capacity is no different and can be analysed in the same way as succession, and indeed the discharge of a financial transaction happens in this case as much as those cases, and we saw how that was treated. And I don't think my learned friend, beyond making that point, seemed to be now saying that, or I took from his submissions from the lack of engagement on it, that if this had, the same thing had been passed by legislation rather than by judicial decision, I don't think he would be opposing me now, because he doesn't seem to have taken a point that because it's capacity, it's different. I didn't discern that from his submissions. His focus in his submissions appeared to be the distinction between legislation and judicial decision.
I think it was taken, I took it that he was saying this is about capacity, which is something different.
Right. Well, I've engaged on that.
Capacity to enter into a contract. And I made the point to him that it's, Adams is a case about a contract being avoided in some way, liabilities under contract being avoided in some way, the contract being rendered void. But he said, oh, well, it's not a case about capacity. So I think he is taking,
still maintaining that.
as it were, two
Well, my
points.
lord, you have my submissions on that. I hadn't discerned that to be his primary objective. I had discerned from his submissions his primary objective to be that Adams and Lynch were concerned about legislation, and that this case was a judicial decision. And as I understood his submissions, he seemed to be saying that the Article 1 protocol cases didn't help me because this was concerned about judicial decisions. And they were focused on legislation. And there was also a point taken about the fact that the case law was in a criminal context, not a civil context. And just engaging with the points, you have my points on why capacity is no different, because it's not form over substance. That's the whole point of Adams.
Well, if you look at the various subparagraphs in that section of Dicey we referred to, the editors there simply talk about discharge of a contract.
Indeed. And that's the
The
point.
different ways of discharging the contract, which obviously include the fact that one of the parties doesn't have capacity to enter into it.
Exactly. And Lord Reed is very focused on what the ultimate effect is of enforcing the law, as opposed to the fact it concerns succession or the bank status or so on. So the question then is the fact that it was done by virtue of a judicial decision any different to the fact it was done by legislation. And in our respectful submission, no, because the question is whether it was unforeseeable, and if it was, the same considerations apply. And there are 2 points that we make in our skeleton. The first is that a retrospective judicial decision has the same effect as a retrospective law. That's in the UCOS case, and that's, I don't need you to turn it up, but it's tab 107 of the authorities bundle, and it's a civil case, not a criminal case. There are also other authorities, but I'll rely on that one. And the second point is the reason we rely upon Article 1, Protocol 1, is that it's clear that there is case law that says depriving of the rights of an individual or entity is in breach of Article 1, Protocol 1, whether it's done by way of legislation or by law, when it's unforeseeable. And that, we rely on that again, and that's in our skeleton as well, and it's the AVPCO case at tab 60 of the bundle. And the relevant paragraphs for your note are paragraphs 52 and 62. So we say that as a matter of law, it's not right to draw the sorts of distinctions my learned friend was seeking to draw. The crucial point is whether or not it's fairly said that the Catholic decision was foreseeable or unforeseeable. And as I've addressed you on this ground, the judge's decision was that it was unforeseeable, and that was Venice's case. My Lord, I didn't have anything further to say on ground 5. I think I addressed you on it. The short point is the Supreme Court decision is clear. The judge's decision is inconsistent with it.
I think you said at an earlier stage, if the claimants in Prato were able to issue their claim and take their proceedings, as they did from 2010 onwards, obvious question is why couldn't Venice?
Exactly, the Lord Brown point in DMG. So, my Lord, unless I can be of any assistance on any further points.
Thank you very much, Mr. Thank you. Right.
My Lord, my Lords, it now falls to me to deal with our appeal, and you have, I hope, our skeleton argument, frank skeleton argument on this. This is the issue of a good deal of interest and some importance of change of position. And it falls into 2 parts, basically, the applicable law and then the application of the English law principles of change of position, specifically in relation to 2 points. One is public policy, or stultification, as we called it in our skeleton, and the other is taking the risk. With your leave, my lords and lady, I'm going to deal with applicable law and the taking the risk point, and learned friend Mr. Paul is going to deal with the public policy point. Okay. Now, turning to applicable law, essentially, and I'll turn to the judge in a moment. This was a case where the judge applied the putative law of the contract to the restitution claim. And we say the relevant rule is that it's the law which has the closest and most real connection to the obligation to repay, which is applicable to the claim for restitution. That is a flexible test. It does include reference to the putative law, but it doesn't exclude references to the other connecting factors, and calls for the usual evaluation of all those connecting factors. And thirdly, we say that if the judge had applied that approach, rather than simply the putative law of the contract, he would have found that Italian law applied to this issue. And the judge's judgment on this point is in paragraph 390 under C3. And what I'm proposing to do is to show you a number of the cases which bear on the right approach to the choice of law in this area, and then draw the points together, and then to review paragraph 390. So if I may, I'd like to begin with the AMF case, which is at tab 28 of the authorities bundle. Which is your volumes 3. And this was a claim in restitution relating to a bribe paid to an agent. And if I could ask you to look at page 597 in the report, page 1019 in printed, or 1025. In the judgment of Lord Justice Saville, just towards the bottom of the left-hand column, much the same considerations apply to the claiming quasi-contract. I accept the proposition stated as in Rule 201 in Dicey, that, and then he quotes it, governed by the proper law of the obligation. And then he goes on on the rest of that page, and the top left, the top right column, to apply that in that approach in that case. And the Lordships might want to look at that, which you'll see that he's reviewing all the different connections. In the familiar way. Now, the next case is the Ugrinef case, which is at tab 44, which is in your bundle 5. Tab 44, and it's page 1927 in the printed, 1936. Paragraph, starting at paragraph 239. Now, this was a claim for monies paid in breach of fiduciary duty. The Christopher Clark quotes Rule 230 of Dicey, which, as within the 14th edition, which as in the 16th edition, sets out the general rule in sub 1, and then has the portion in sub 2. And the relevant bit is 2 sub A. And in 240, Christopher Clark, the commentary explains the general principle is of English law is to subject claims in the law of obligations to the law with which the obligation has its closest and most real connection, i.e. of identifying the law which has the most significant connection with the claim. And in 241, the judge refers to Cheshire and North, and a case we'll look at in a moment, Baring Brothers, Lord Penrose, who referred to the law of the country with which, in the light of all the facts and circumstances, the critical events have their closest and most real connection. And then yes, and then at the top of page 1929 in the printed, so this is just above paragraph number 247, the top of that page. Any obligation to restore an unjust enrichment must in principle be determined by its proper law, which is intrinsically that law which has the closest connection to that obligation. Rule 302A to C indicates what in the instances to which it refers is likely to constitute that law, but the indicators of the likely result of the application of the principle cannot replace the principle itself. And then he refers to sub C, and then if there's a contractual or similar relationship between the claimant and the defendant, the law of that relationship is likely to govern. And at 252 on the next page, yes, so he's, if your lordship has read that, that's on the question of what the obligation is that one's looking at, and connects up with the point in Baring about the critical events. What we draw from this authority, my lords, firstly, it confirms that the view that sub 2A, B to C of the rule in Dicey provide indicators, but they do not replace the rule. And secondly, Christopher Clark seems to endorse the view in 240 that what one's looking at for is the obligation, the law with which the obligation has its closest and most real connection. But recognises that what you can't do is go and look at in this case the English law to see what the obligation would require under English law, and then apply that. So obligation is a difficult word if what you're meaning is legal obligation under some system of law, which is why Lord Penrose prefers to talk about critical events. So then moving on, if I may, Baring Brothers, tab 97 in under 13. This is the Lord Penrose decision. And I wanted to start at page 5327 in printed. 5333, I suspect, in digital. And This was a claim for sums which have been paid ultra vires by a local authority. I'd like to start slightly earlier than the page reference I just gave you, I'm afraid. If I can withdraw that reference and take you to page 117 in the report, 5317 imprinted. Probably better to start here. 117 in the report. And towards the bottom, you'll see the judge quotes Dicey Morris in the 12th edition, and your lordships can see the rule there set out. And then what follows is a very close examination of the rule and the authorities referred to in it in Dicey. And what you get at page 121, 5321, just at letter E, it must be concluded that, so far as concerns the authorities referred to, the sub-rule is wholly without judicial support. It may similarly be advanced as a matter of principal discussion without any obstacle in relevant adverse judicial comment. The authorities referred to thus far are, in my opinion, best seen as neutral. This is a point we'll see again in later cases. And then at page 127 in the report, 5327 printed, the conclusion of Lord Penrose at letter C, in my opinion, in my view, however, on the flexible approach, one may reasonably accept two propositions. First, that the restitutionary quasi-contractual obligation is governed by the proper law of that obligation, and B, the proper law of the obligation is the law of the country with which, in the light of the whole facts and circumstances, the critical events have their closest and most real connection. Where the restitutionary or quasi-contractual remedy is required because of the inapplicability of a contract or the failure of a contract, the existence of the contract or the attempts by parties to enter into the contract will be relevant and material factors in resolving an issue which arises, but will not per se be determinative of that connection. So what we draw from this is the statement by Lord Penrose of what he calls the flexible approach to the rule in Dicey. That is that the sub-rules, including sub-rule A about the putative law of the contract, are not inflexible, but are to be applied flexibly. Secondly, here is the reference to the critical events. One can see from the context what he's getting at is identifying those things which you need to look for when you're looking for the connecting factors. And this is what was cited by Christopher Clark in Huguenot. Now, the next authority I wanted to show you is one of the Fiona Trust cases. This is in tab 48. Volume 6, tab 48, and it begins at 231. 2315 imprinted, so 2321 in the digital, paragraph 160. And Mr Justice Andrew Smith refers to Dicey the law governing the obligation to restore a benefit is stated tentatively here. And at 161, if the rule is intended to be applied rigidly, it's not supported by authority, and a more flexible approach has been preferred in the Scottish case of Baring, cited by Christopher Clark in Ugranaft. And then it quotes from Christopher Clark's judgment. And then, if I may, on the next page, 2316 in printed. Well, it's actually just pick it up from the bottom of the previous page. They submitted that. This is standard maritime defendants. The restitutionary claims for knowing receipt are governed by the law which has the closest connection with the obligation to restore the unjust enrichment, which in cases in which the obligation arises in connection with a contract is likely to be the law applicable to the contract, and otherwise, where the claim is in respect of real property, the law of the place where the enrichment occurs. The difference between the parties' formulations of the rule to determine the governing law appears to be that the standard maritime defendants referred to the law with which the closest and most real connection with the claims. The claimants referred to the closest connection with the obligation to restore the receipt. This distinction doesn't, as I see it, give rise to a difference of any significance, at least for present purposes, but if it matters, I would adopt the rather broader formulation of the standard maritime defendants. So, closest connection with the claims. So, what we draw from this, my lords, is the view of Mr Justice Smith that the rule is not to be applied rigidly, and indeed flexibly, and his preference for closest connection with the claims. And then, if I may, the Prato case, which is at tab 62, which is bundle 9. Page 3582 in written. This is the judgment of Mr Justice Walker. In this case, as you know, that the facts were very similar to our case. The claim that the swaps entered into were void due to various provisions of Italian law, found to be void, and that gave rise to a counterclaim in restitution by Prato with the defendants. And the issue was about the change of position defence here. And at paragraph 161, Mr Justice Walker begins to address Dicey. And can I ask you, your lordships, to read that paragraph?
What page number for that, please?
3582 in written, 3588 on screen, if your lordships, yes, your lordships on screen. Paragraph 161. And then, if I may ask you also to turn over and read paragraph 164. And then lastly, paragraph 168 on the next page. And what we draw from these paragraphs of this authority is that in this case, Mr. Justice Walker held that he would have no regard to the putative law on the facts of this case in arriving at the applicable law. That's paragraph 168. And that's...
Well, as you say in your little chart in your skeleton, this case is a very far extreme,
yes,
which goes further than any other case. And Lord Penrose makes the point that where it's a claim under 230A, the fact that the contract is governed by English law is obviously a highly relevant consideration in the exercise of a in engaging in the flexible approach.
yes.
It means, and by all means show us this, but it seems to me it's wrong.
Well,
To completely disregard the
it's-
contract
and
just seems
it's-
to me to be ridiculous, frankly, because the payments were made for years and years and years pursuant to what the parties thought was a valid and binding English law contract. They were wrong about that, but the fact is that that's the basis on which the payments were made. So the idea that English law, as the law governing that putative contract, is not of any relevance seems to me to just be incorrect, wrong.
and my lord, it's not our...
No, I
it's not
understand
our
that.
position, yes.
I understand that.
But it is
It
necessary.
doesn't follow from that it's not Italian law, because if you engage in the flexible approach, you get to Italy. But it seems to me this way of getting there is not helpful.
My lord, yes. Now, what one does get from is the flexibly point, the point that you just...
Yeah, but I think that's you get that from
Yes.
both Ugranaft and Fiona Truss. You don't
Yes.
need this case.
You get a rather qualified flexibility from Prato, because you put one factor on completely out of account.
Yes,
Yeah.
yes. I mean, depending on your view of what the judge in this case has taken, and we'll come to the judgment,
Yeah.
he may be more on that, and I would say he is more towards the Prato end, because he's, well, we'll see that. I won't anticipate that too much, but
Okay.
that's where we are. So then Busto, if I may, tab 77, which is your volume 11. There's a Busto decision, tab 77, and it's page 4705 in printed. 4711 digital. So paragraph 411. And if I could invite you to read that paragraph.
411.
411. So some discomfort with applying parte. What we draw from this is that in this case, Mr Justice Cockrell distinguishes parte for two reasons. One is that there was weight to be given to the putative law because it was the law applicable to the question of capacity. So, on any view, that's a factor, a connecting factor. And two, on this case, there were factual connections with outside Italy and with London. So the bank here had acted through its London branch, and the enrichment had taken place in England. And overall, she would have concluded closest and most real connections were with England. Now, those are the authorities, apart from Dicey, I wanted to show you. And then, if I can ask you to turn up our skeleton on this, please. Paragraph 24. So this is bundle C6. And
yeah.
And it's page 120 in printed, I believe, 126 in digital. So this is, I hope, a convenient place to see the different formulations. On which we make the two submissions there. On the correct reading of Dicey, as it now is, we say it is consistent with the flexible approach, and it's now adopted that. And secondly, we say that if not, insofar as it provides support for a more prominent or even decisive role for the putative governing law, then it's not supported by authority and is wrong. And then if I can just take you straight to it, you'll see in paragraph 29 we refer to Dicey 14. Of course, we're now in Dicey 16. And quote from Dicey 14, Clause 2A seeks only to assist in the identification of the proper law of the restitution obligation in circumstances of contractual failure. It doesn't say it's an inflexible rule, which must be applied without exception to every case connected to a contract. And in Dicey, and at the bottom of that paragraph, Dicey 16, it's there said that in determining the proper law of the obligation without further guidance intended to be applied flexibly was given as to the general principle in certain particular cases. Now, there is also, I don't propose to take you to it, paragraph 28, there's a reference to this in the Matos case by Lawrence Collins, as he then was, Mr Justice Lawrence Collins, and your lordships will see that, which is also supportive of the proposition that we make, that the rule is flexible. And we summarise our position at paragraph 30. And your lordship will see B. A flexible test governed by the proper law of the obligation, identifying the country with which the obligation claims or critical events have their closest and most real connection. The sub-rule is to be applied flexibly. And that's probably all I need to say about that. And finally, having done all that, can I now take you back to 390 of the judgment?
Just before you do that,
Yes.
does it make any difference in your submission whether the test is the closest connection with the obligation or whether we are looking at the critical events? You've taken us to different formulations.
Yes.
Mr Justice Andrew Smith didn't think it made very much difference, and I would like to know whether you say that it does in this case.
Yeah, 2 points really. One is we think on any view, submit on any view, it doesn't make any difference. Two, our approach would be obligation, closest most real connection to the obligation. But the Penrose critical events is a useful way to identify what is going to be, how you identify the obligation. What you can't do, as Christopher Clark said, is identify the obligation by reference to English law or Italian law.
Well, what I suspect might be said against you is that if the test is connection with the obligation, then the obligation to repay is the mirror image of the obligation to pay in the first place. And that if the test is the critical events, it might be said that the most critical events are the payments made to the banks pursuant to what were thought to be English law obligations.
Well, my lord, that may be said. The obligation in our submission is the obligation to repay, not the obligation under the contract, because the contract is void. So we're in a world where it's just gone. And
But you have, but in order to get to that, you have to look at why it was paid in the first place.
the parties thought that there was a contract. Yes, that, I'm not,
So
not
they
shying,
thought they were making payment under the contract.
yes, I'm not shying away from that. What I,
But the point my lord's making is if they thought they were making payment under the contract, then what will be said is that the relevant obligation is the obligation to repay, which is a mirror of the obligation to pay.
well,
Anyway, the answer is it's a relatively short, if rather difficult point.
and my lord, that's not
And I
the
see
approach.
considerable force in your argument that we have to adopt, as it were, a more flexible approach by reference to the limited number of first instance cases which deal with this.
Yes.
Assuming that we don't just say, well, with the Court of Appeal we can do what we like, but we're not going to do that.
And just to finish this point from my point of view, it isn't the approach, answering my Lord Justice Mayles' point, in the cases we don't see that the judges are adopting the view of obligation that my Lord was putting to me in then analysing the facts. So if the very first case I showed you, the Lord Justice Savile case,
That was not a contract case, was it?
No.
no, but I mean, one could look at any of these cases. What they're then doing is looking at all the connecting factors. And as Andrew Smith said in the Mr Justice Andrew Smith said in the Fiona Trust case, it's actually very hard to see any difference between them. And that would not be so if really the obligation in question was the obligation under the putative contract. Now, if I may, just looking at paragraph 390 of the judgment, I'm satisfied in this case
390.
Yeah, 390 of the judgment. And looking at the first three lines of paragraph 390, I'm satisfied in this case the unjust enrichment claim has its closest most real connection with English law by reason of the choice of law clause in the Venice Master Agreement. I've reached that conclusion for the following reasons. So it's quite clear from the opening there that the judge is coming to this decision because of the choice of law clause. And that then is also apparent in the grounds sub-Roman 1 to sub-Roman 6. I won't read them out, but just, if I may, just looking quickly at them. They're all grounds that relate to the putative law. Article 1 of the Rome Convention, that's the rule there, putative applicable law. That reflects the importance attached to a putative applicable law, is what the judge says. On that basis, English law has been applied, in this case, to issues relating to...
Well, that's Mrs. Justice Cockrell's first point in Buster, isn't it?
Yes.
The same point.
Well,
which you accept as a relevant consideration.
yes, yes. It's exactly. But here, in sub-Roman 2, in my submission, the judge isn't making, well, he's making this point, connects it with sub-Roman 1, and these are reasons why the putative law determines the applicable law. But that's the reasoning as we read it here. It's not, so if we go on, we'll see that he's not, as it were, totting up connecting factors one way and the other. Sub 3, those matters are sufficient to show, even when the validity is in dispute, or the contract's void, the party's putative choice of law is still legally significant. So that's tying together 1 and 2 with the conclusion in 3. And then 4, again, wrong putative law. There is at least a logical connection between the system of law which decides a contract's void, English law in this case, and the law to be applied in determining the consequences. And then he quotes the Arab bank case. And in the middle of that quotation, you'll see Lord Justice Jenkins. It would at least be logical also to look to Israeli law for the consequences of the cancellation, and to regard any substituted obligation as the creature of that law.
Yep.
And then sub 5, in Haugesund, Lord Justice Aikens appears to have assumed that English law governed the restitutional claim in respect of a void contract, which would have been governed by English law, and addressed the significance of the foreign statute to such a claim, not on the basis that that was being argued by reference to English law only as a matter of convenience, but on the basis that English law was indeed applicable. And I'll come back to that, if I may. And then 6, finally, the payments in question were made on the understanding they were required by English law obligations, which links up with the point I think my Lord, the Vice Chancellor, the Chancellor was making just a moment ago. So this is the understanding. The fact that the payments were made and received on the basis of assumed English law obligations is, to my mind, highly significant. It being the natural expectation in those circumstances, English law would apply to issues relating to security of receipt and rights of recovery. So I do accept that sub 6 and possibly sub 5, are not directly putative law, but they are very closely connected to putative law. And taken as a whole, this paragraph indicates that the start point for the conclusions of the judge on this point are that by reason of the choice of law clause, it is right to apply the English law. Now, as to this, first of all, we submit that on this, the point, the judge fell into error on the correct approach to deciding which law was applicable. The judge, in our submission, should have applied the flexible test, and that and evaluated the connecting factors. And my lord, apart from the points I've made about the content of these points, we know in this case that the judge didn't do that is, apply the flexible test, because we don't see him identifying any of the other connecting factors, in this case with Italy. And I will come on to dealing with those when I say how the test should have been applied, but there are.
But it is the case that he articulates it as a test of the closest and most real connection.
Yes.
He's not simply saying, I'm applying paragraph A from Dicey.
No, but that's the way you would say it if what you were doing is reading the introductory bit of Dicey, which is closest and most real connection to the obligation. And then the way Dicey is phrased, and we see it in my skeleton, is then to say that in the case of void contracts, the applicable law is the putative law. So you can see it, for instance, at paragraph 25.
Paragraph 25
of my skeleton. That is Dicey 8, but it isn't different in this respect.
Your point is that he loads up the scales of what goes on the English law side of the balance, but there's nothing here to show that he is considering what goes on the Italian side and then seeing where the balance comes down. It may be he had it all in mind, but he doesn't say so in the judgment.
My lord, exactly so. And yeah, my lord, yes. I will come on to my submissions, but about what the connecting factors are. But it's in my submission, it's impossible in this respect to conceive that you would go through the process of identifying to yourself and evaluating the connecting factors without without articulating them and weighing them up, because everything else in this case points to Italy in our submission. Parties of Italian performance was in Italy. Everything was in Italy. It's just the proper law was chosen to be applicable law. So,
but the analysis would be this, would it? That if you're right about that, obviously if you're wrong, it doesn't arise. But if you're right, then the judge has made an error, meaning we have to do the exercise of balancing ourselves.
Yes, that's correct. That is my submission.
Even though we might arrive at the same.
Even though you might arrive. Yes, it's perfectly conceivable, but I would urge your.
No, I follow the point. I know you urge us not to. But I follow the point that you say. Well, the judge does at least, as my lord says, he may have had these matters, the Italian matters in mind, but he doesn't actually say so.
Yes.
And on the basis that these submissions were the submissions in favour of Italy were addressed to him, it's perhaps a little surprising, although by the time he got to page 126 of his judgment, he'd been losing the will to live.
Everyone is lost in admiration for the...
Absolutely. Whether he's right or wrong about all these issues, it is the most magnificently written judgment. Okay,
so that was my first... My first submission. I then wanted to briefly just look at these sub points in 390 because there are some points worth making about them. Sub 1 to 3, which we looked at a moment ago, putative law in some other areas. Now, the point we'd make here is that you have to be very careful to distinguish why you're applying putative law. Where you've got a question as to what law to apply, as you have, say, under Article 8.1 of Rome, and you don't know yet if the contract is binding, then as a matter of pragmatism, you apply the putative law. It's a bright line, it's readily identifiable, and one can see the sense in the convention parties agreeing that. It's quite different where what's happened is that it has been held that the contract is void. So it's no longer an issue. That's not the question. The question is, that being so, what law should apply to the claim for restitution? And so references to putative law in these other areas, in my submission, don't carry the matter very far. Now, sub 4 logic, one, of course, can see the desirability of having one law applying to all the issues in the case. It's absolutely, unfortunately, not always possible, and this is actually a paradigm case of that, because you've got capacity, English law and Italian law. And there's absolutely no, under our law, that is always going to be the case where you've got a foreign incorporated body and an English law contract. That again, one can see the desirability of it, but it in my submission, isn't a reason always to apply the putative law. Sub 5, I said I'd come back to this, Haugesund. In that case, the judge has referred to 97 to 100 of Haugesund. In that case, it was in fact common ground that English law applied, and that was recorded in his judgment at paragraph 8, which isn't referred to here. And the reference is tab 49, page 2692 in the printed. And the last one, presumed intention. Now, the point being made here, natural expectation. Well, in our submission, by no means necessarily so. If what you postulate is you've got two Italian banks, an Italian local authority, they choose ISDA Master Agreement, English law, and they're then told the contract's void for lack of capacity. And then you postulate, well, you ask the question, well, so all this money's got to come back, one way or the other. What law applies to that? There's no reason to assume that they're going to say, well, it's also English law. That the money's paid over it's paid by one party to the other in Italy. They're Italian, and they have other Italian law contracts going on between them. I'm not saying that you can assume that it's going to be Italian, but my proposition is you can't assume that, certainly not in order to then say, well, putative law must always determine.
Is it helpful to ask what the parties would have said? Because ex hypothesi, they thought they were entering into a valid contract, and the question, what law is going to govern any repayments claim if this contract is void for lack of capacity, is going to be a million miles from their minds.
Well, my lord, yes, and that's possibly another reason not to go down this road.
But I asked you that because you were saying, what would the the parties have thought was the relevant law.
Well, my lord, I was trying to address the natural expectation point. What I understood the judge to be saying is, well, the expectation of the parties, if they thought about it, would be in this, if the contract's void, then it's going to be determined, the restitution right is going to be governed by the English law. And we say there's no reason to make that leap. And then if I can just on this, just invite you to look at a little bit
The
of...
judge is making the point, isn't he, that to the extent that the parties ever thought about it, not suggesting that they had, then their natural expectation would be that, given that the payments were made pursuant to obligations under an English law contract, that in the event that the money came back for whatever reason, there was a right of recovery. Be governed by the same system of law.
Well, my lord, that is the proposition. But if one just looks at it slightly differently, if I may suggest, the parties here were in contractual relations. So they had a mandate agreement, as well as this the swap transactions. And that was governed by Italian law. And the payments, as I say, has been made in Italy. If they're told, well, there is no contract anymore, then
The payments weren't made pursuant to the mandate agreement.
no, they thought, but absolutely, they thought it was going to be governed by English law. But then you, in my submission, you then have to postulate they're told there is no contract under English law.
One way, another way of looking at it, if you're right about that, really you can't look at what would have been the natural expectation, is to look at it in the way in which Lord Justice Jenkins at least provisionally would have looked at it, which is to say, well, it logically makes sense if there was a payment pursuant to a contract governed by system of law A, in the event that there's repayment and money comes back, it should be governed by the same system of law.
Well, my lord, what I would say about that, what I would submit is that it is a perfectly admissible connecting factor to be taken into account.
Yeah.
Absolutely. As is the fact that there is a putative law. The putative law is English.
Yeah.
The parties had thought they were signing up to an English law contract. Absolutely. But it's just then, you do have to look at everything else, in my submission. I was just going to just draw a morsel of support for the point I was just making in my skeleton at paragraph 44.
44.
Paragraph 44. And your lordships may be interested to see Guttridge and Lipstein in the middle of that paragraph, 1939. I would like you just to read that bit in italics.
Yeah, I mean, yes. The problem with looking at Guttridge and Lipstein is that it was written more than 25 years before Lord Gough and Professor Jones produced the first edition of Gough and Jones, when the law of restitution wasn't really recognised. And I mean, I can remember being taught by Professor Tritle that this was all to be, the whole of the law of restitution was an artificial construct which was to be assimilated into the law of contract. And that was in restitution seminars. So, I mean, it's a long, long time ago. I think
It's the mind boggles.
it's quite difficult to go back to 1939 and say, well, what an academic thought in 1939 is really worth looking at.
Well,
today. I mean,
it encapsulates the point.
no, I
and-
understand. I'm to some extent, I'm having a bit of fun, Mr. Cox.
Yes. No, absolutely.
What does the current edition of Goff and Jones say about this, if anything? Presumably it doesn't. About what system of law governs.
We haven't either side put that in.
No, I just wondered if there was anything at all.
On our side, no, but because it doesn't help nor hinder, but
Yeah, okay.
I'll no doubt be told if I'm wrong.
Yeah.
So, my lords, I then just conclude really. Those are my submissions in this case, what the error was, unfortunately, on this point. The judge, in effect, has and I ought to say I will just deal with the application to the facts, but on the question of the error, the judge on this point has fallen into error because he has adopted the approach of applying just the putative law, it seems, to the question of which is the applicable law.
Yeah.
And that's not the correct approach. And then, in relation to the facts, if I can ask you please just to, they're encapsulated in our skeleton paragraph 47. So,
Yeah.
48, there were pre-existing contractual relationships, and that's the mandate agreement, which provided for Italian law.
Does that mandate agreement have any continuing life? I mean, we're testing this now, we're not as at 2007. We're testing it in the light of the payments made. To what extent does the mandate agreement have relevance?
My lady, it is a good question, and I'll have to give you the answer to that. As at the moment, I don't know.
Well, it's part of the background.
Given where we are, with the,
I mean, it seems to me, at least, at 49, the place of any unjust enrichment as Italy is a stronger
yes.
argument.
Well, yes. I suppose that there's also this to be said in relation to the first point, that that at the time of the swaps, that there was a mandate agreement in being. Whether it still is, the swaps having been declared void, I don't know. I can't tell you, I'm afraid. And I quite take your ladyship's point about now relying on the defence. But at the time of the contract, it was there. Yes, the second point, place of payment, place of entry into the transactions, place of receipt. So the place of the unjust enrichment is Italy. And third, there is a more technical point of some relevance in my submission. This was a case, I don't need to ask you to turn it up, but the confirmations, the trade confirmations for the swaps, specifically included. The trade confirmations for the swaps included the portions quoted in the third line here, that Venice had been classified as a retail client pursuant to Article 26 of the Consub Intermediaries Regulation, that Dexia was subject to the control of DCL, which was authorised by the Bank of Italy to carry out investment services and activities pursuant to that Italian law.
These are the regulatory So
Yes,
the two banks
it-
were subject to Italian regulatory regime.
Yes.
But did that govern in any way the payments that were made by?
No, I don't say
Yes.
that. It governed the banks
Yeah, but it didn't govern the payment obligations pursuant to the swaps.
No, I don't say that. I don't. No, it isn't part of our case. That.
So
What
again,
is-
it's really part of the background rather like the mandate agreement.
Yes, but it's very precisely in the swaps themselves. So it's actually in the swap documents that the parties have seen fit, both of them, to record and agree that the banks are subject to Italian regulation. And Venice has been classified as a retail client. So
And that-
that is another connecting.
Was that because presumably that was that something that was required by? Presumably, it was required by the Comswap intermediaries regulation. Was it?
I don't know why it was in the confirmations, but being regulated, they obviously had to comply with regulation. But I don't know why it was in these regulations, in these confirmations. It's an unusual feature of this particular transaction, in my own experience. But it's right. So there it is. Those are the factual matters, and on any view in my submission, you'd need to take those into account, and as well as the putative law and any views you have about that expectations. And my lord, and our submission is, if you do, the contract being void, then all the other connecting factors point to Italy. There's really just the putative law. And the
Okay.
My lord, those are my submissions.
Right.
Mr. Paul will now deal with part of the
Mr. Paul, given the acoustic difficulties in this courtroom, if you want to move forward into the front row, that would.
I fear, my lord, it may be too inconvenient.
Too
to
inconvenient, very well.
To move my bundles forward, but if your lordships can't hear me, do please say, and I will
That's
speak
fine.
on. I fear a greater concern may be that the APUS transcribers won't be able to hear me because the APUS microphone is a row ahead. So again, if your lordship could please say if what I'm saying ceases to be picked up in real time.
Doesn't seem to have been picked up yet. Let's just see. Seems to have stopped. I will not be able to hear counsel from that position. Can we, if we gave you 5 minutes, could you arrange? Or?
That could certainly be done, my lord, and I should say as well, I'm reasonably confident that we'll finish this part at least by 4 p.m. today.
Well, we're running, I think, technically about. I think you've got about half an hour in hand because on the basis I can't sit beyond 4. You weren't supposed to start these submissions till 3 o'clock, Mr. Cox. So I think we're doing quite well. So we'll rise until 3 o'clock so you can sort that out.
Very, very grateful, my lord. Yeah, if you don't mind.
Oh, sorry. Yes, I do. Yes, just.
Maybe easier if I simply move. And if we get to the next part where Mr. Cox is speaking again, we'll still pick him up.
good.
That was quick.
Starting off with a 3.
I'm so scared my phone will go off. And that noise happened. I thought, oh my God, my phone's going off.
Do you want to put that in the document? Yeah, draw it out. You got enough room?
Yeah, I'm fine.
Move up. How long do you think you will be?
Probably about an hour. So
So you'll go for the rest of today, you
I think so. Yeah.
You can relax.
Hmm?
You can relax.
think? Exactly. I'm just trying to work out how intensely I had to listen, whether the transcript would do.
I think no, can't guarantee. Depends very much on them, of course. But I think I've got about an hour's worth of submissions.
Well, I hope you might finish a bit early.
Yeah.
Because I hope you are. It can't be longer. It's more than that. Well, we'll see. I mean,
I'll be really short.
yeah, so hopefully so. Very nice.
Correct.
My lords, my lady, before turning to ground two, may I just respond briefly to the question raised by my lord the Chancellor about what the current edition of Goffin James says
Oh,
on the
yes.
topics your
Thank you.
lordship was just discussing, Mr Cox. And so far as we've been able to tell during this short break, Goffin James says nothing at all about conflict of laws, or indeed any of the cases that your lordship was just considering.
I thought it didn't, but I just wanted to check. Okay, thank you. It's helpful.
So, my lords, my lady, to ground 2A and stultification. By ground 2A of its appeal, Venice contends that the judge erred in allowing a defence of change of position in principle in respect of payments made by the banks under back-to-back hedging swaps in circumstances where to do so would have the effect, we submit, of substantially enforcing contracts which were void pursuant to the ultra vires doctrine. As your lordships would have seen, there are 3 first instance decisions in which the availability of a defence of change of position in such a context has arisen for decision. The first is the judgment of Clark J in South Tyneside NBC and Svenska. Second is the judgment of Hobhouse J in Westdeutsche Landesbank and Islington. And in both of those cases, the learned judges held, albeit for somewhat different reasons, that the defence was not available. And the third case is, of course, the present case, in which the judge decided not to follow those judgments in light of what he described as developments in the law of unjust enrichment. And for completeness, my lords, I should also draw your lordship's attention to the brief obiter consideration of the same point by Mrs Justice Cockrell in Busto at paragraphs 414 to 415. I don't intend to say anything more about that because, as your lordships may have seen, all Mrs Justice Cockrell does is refer back to the judge, Mr Justice Foxton's reasoning in school facility and indicate that she would be minded to disapply the defence in light of that reasoning. But she doesn't add any analysis of her own. My lords, Venice respectfully submits that the judge erred in not following the judgments in Svenska, Westdeutsche and Islington, and that the developments in the law of unjust enrichment to which he referred did not require such an outcome. And for the purposes of ground 2A of the appeal, my submissions will focus on the reasoning in Svenska, whereas in addressing ground 2B, Mr Cox will focus on Westdeutsche and Islington, on risk-taking. And before turning to the detail, may I begin perhaps by seeking to set some ground and articulating to your lordships the propositions which we invite your lordships to accept on this part of the appeal. And by way of clarification, in our oral submissions, we will be advancing both a primary case and an alternative case.
Right.
The primary case is that a change of position defence is not available, where allowing it would prevent the reversal of benefits conferred pursuant to an ultra vires contract, because we submit that to do so would stultify the ultra vires principle, which we say is the policy rationale for ordering restitution in the first place. Of course, that primary case, my lords, would apply both to cases of anticipatory reliance, of which the present case is an example, and also to cases of consequential reliance, that is to say where the change of position followed receipt of the benefit in respect of which restitution is sought. So that, my lords, is the primary case, and you'll have seen that's the way we put it in our skeleton. We focus on the wider proposition. The alternative case is that a change of position defence is only precluded in an ultra vires context in cases of anticipatory reliance. It's only in those cases, on this analysis, we submit that reliance is impermissibly placed on the assumed validity of a void contract as the basis for the change of position.
Yeah.
Those two cases are connected by the ultra vires doctrine, but there are important differences of focus. In the primary consideration, and this again is just to set the scene, the primary case involves, we submit, consideration of what we say is the underlying rationale for the disapplication of change of position to certain restitution claims. And that, we say, is the principle of stultification.
Yeah.
The alternative and narrower formulation focuses on what we submit on the judge's approach, gives rise to an illogical inconsistency between how ultra vires contracts are treated in the change of position context, if the judge is right, versus how they're treated in what we submit as an analogous context of reliance-based estoppels. And I should also make clear up front, my lords, that either the primary case or the alternative case, if accepted by your lordships, would involve your lordships finding that the judge was wrong, not just in the present case, but also in his earlier judgment in schools facility.
What happened in school facilities? Did it go to the Court of Appeal?
It went to the Court of Appeal, my lords, on a different point, on a question of counter restitution and how the counter restitution defence interacts with other elements of a cause of action in unjust enrichment. At what stage of the analytical sequence one considers whether it's impossible to give counter restitution. But there wasn't any consideration in the Court of Appeal in schools facility of the judge's conclusion in relation to change of position. It's fair to say there's no criticism of it that I'm aware, but the point wasn't an issue before the Court of Appeal.
Okay.
My lords, in support of Venice's case on this ground, I'll be making three main submissions, covering both the primary and alternative formulations. The first is that, as a matter of English law, the change of position defence is denied, where allowing it would stultify the policy reason for ordering restitution in the first place. Now, first submission I understand to be partially common ground, perhaps not quite in the way I've just articulated it, but what is common ground, as I understand it, and this is the bank's skeleton argument of paragraph 53, is that there is a principle of stultification which arises to conclude a change of position defence, at any rate in a statutory context. One is looking at whether a statutory policy would be undermined by allowing the defence of change of position. That's at page 158 of the core bundle, paragraph 53. I wasn't going to take your lordships to it because I hope I've fairly set out what we understand to be the extent of the common ground which doesn't go as far, I think, as the case I'm advancing, which is that stultification isn't simply limited to questions of statutory interpretation and statutory policy. So that's the first submission. The second submission is that the ultra vires principle is such a policy, and it would be stultified by allowing a change of position defence in respect of a restitutionary claim, which is intended to reverse the transfer of benefits conferred pursuant to an ultra vires contract. And that we submit, just foreshadowing a point arising on the authorities, is what distinguishes this situation from those considered in some other authorities relied on by my learned friends, namely Haugesund and recent Privy Council judgment in Trin Salvage, where in those cases the ultra vires principle was held to be no barrier to the restitutionary claims succeeding, because what those claims sought was the reversal of benefits transferred ultra vires. So in those cases, ultra vires didn't prevent you from advancing a restitutionary claim, where what you're seeking to do by your restitutionary claim is to reverse the transfer of benefits conferred ultra vires. And we submit that the reason allowing such a claim would not stultify the ultra vires principle is obvious. The claim of that nature is giving effect to the ultra vires principle.
Which cases are those, sorry?
As is Haugesund in the Court of Appeal and Trin Salvage, a recent Privy Council decision. Trin Salvage isn't referred to in my learned friend's skeleton argument, but they've added it to the bundle. It's a very recent authority, but we understand that it's to be relied on in this context.
No. Okay.
So that, my lords, was the second submission. The third is, in any event, and this reflects the narrower formulation of Venice's case on Brown 2A, we submit that just as in the case of reliance-based estoppels, the change of position defence is precluded, where it requires reliance on the assumed validity of an ultra vires contract. As we submit, will likely be the case in an anticipatory reliance context. I'll be developing those submissions, my lords, by reference to the authorities and also picking up some points made by my learned friends in their skeleton argument along the way. And I should also say at the outset that the propositions we rely on this part of our appeal haven't been the subject of a decision at an appellate level, and that's why I will be referring your lordships to both first instance authority and also to over to dicta. Before turning to the authorities, may I also just make two brief points by way of overview concerning the factual context in which these issues arise in the present case. And the first issue concerns what is at stake in relation to this part of the claim. And your lordships will have seen the present claim was the subject of an order for a split trial, and thus if the judge's orders are upheld, then the question of the quantum of Venice's restitutionary claim and whether it's completely cancelled out by the bank's change of position defence will be the subject of a second trial. However, and that all hasn't been worked through yet, it's been effectively stayed pending this appeal. However, the bank's position, which they have articulated, is that the back-to-back hedging swaps they entered into provide a complete defence to Venice's restitutionary claim. And your lordships will see that position articulated in a letter from the bank's former solicitors, Vincent Masons, dated 21st of October 2022. I don't propose to take your lordships to it, but that, if your lordships note, is that supplementary bundle, tab 69, page 717.
I think you read it as
Yes, your lordships may have read it. And all we submit is that the issue in this case is a stark one, because if the change of position defence is permitted, then on the bank's case, despite at this stage of the argument, the position being that Venice lacked capacity to enter into the swaps because local authorities did not have capacity to do so, Venice will not be able to recover, subject of course to limitation, the around 70 million euros of public money dispersed as payments pursuant to those void swaps. And that is what is at stake, and we do submit that's a conclusion which requires some consideration.
Are we supposed to decide whether, if change of position runs, it operates as a complete defence or only as a defence to the extent that payments have been made pursuant to the hedges, or is that all for later decision in the first instance?
That, my lord, is for later decision. What the judge found is that in principle a change of position defence is available in respect of payments made under the back-to-back hedging swaps, and the question of the quantum of that change of position defence, and the judge drew attention to some possible complexities which could arise on the facts, will be the subject for a separate trial. So your lordships are only asked to consider the point of principle which the judge decided.
The point of principle.
So, my lords, that was the first point. The second point concerns the nature of the contracts at issue in this case, that is to say a swap and indeed a hedging swap. And the point I'm about to make is principally relevant to the alternative way in which Venice puts its case, which focuses on anticipatory reliance. And to make this point, if I could just please refer your lordships to a statement of Lord Justice Popplewell in the school's facility judgment in the Court of Appeal, which I'm not relying on for any proposition of law, but simply as a convenient description of the factual context in which one is considering these issues.
Yeah.
And that judgment is at Authorities Bundle tab 76. For those in the hard copy, that is volume 11. And the paragraph to which I wanted to refer your lordships is paragraph 58.
58.
Which should be at page 4606 of the hard copy, or 4612 of the electronic. And once your lordships have paragraph 58, I would just invite your lordships please to read that. That is, of course, not telling your lordships with respect to anything your lordships don't already know, but what it is doing in my submission is conveniently summarising one point which we submit is relevant to anticipatory reliance, and this is that when one is dealing with an interest rate swap, at the point of entry into a hedging swap, the question of whether the banks would have received any benefit at all under the swaps with Venice, both in relation to any particular accounting period and also at the conclusion of the transaction viewed as a whole, is essentially indeterminate. And that may be, we submit, a relevant distinction when one comes to consider what precisely one is relying on when one enters into the hedging swap.
Well, it's not quite like that, is it? If you look at it this way, that is to say that what the banks get from their hedging swap, which they get at the outset, is that they are hedging their own position so that they are effectively locking in their profit on the transaction, as distinct if they don't have a hedging swap or they're not allowed to have regard to it, being put in a position where they are involuntarily speculating on interest rates themselves over the whole period. And one might think that's quite a big difference from the bank's point of view, and transforms the nature of the transaction for them.
Yes, I accept that, my lord. What I was focusing on was the position as between the banks and Venice at the point in time in which the banks choose to enter into the hedging swaps. And the question at this stage of the argument is, what was it on which the banks relied when they entered into the hedging swaps? And the submission I was making is that in an anticipatory reliance context, one can see that in some anticipatory reliance cases, even perhaps in void contract cases, it may be possible to say that one is relying on the anticipated receipt of a payment, even though the vehicle for that payment will be the performance of contractual obligation. I don't want to put this point too highly, but there may be a distinction where the type of benefit which one is anticipating is one which is actually indeterminate under the void contract. It may be predictable, but one doesn't have any certainty that one will acquire it when one changes one's position. So that, my lord, was just a background point. Can I then please turn to the authorities, starting with Svenska, which your lordships have at volume 3 of the hard copy, at 27. That should be page 992 of the electronic bundle. This was a claim by a local authority for restitution of sums paid pursuant to an interest rate swap, which it was common ground was ultra vires and void in light of the House of Lords judgment in Hazel. The local authority sought restitution of the net sum of 230,000 odd, and the bank sought to rely on hedging swaps as a change of position defence. And the sole issue before Clerk J was whether the bank was entitled to rely on a change of position defence. Can we please then go straight to the consideration of the change of position defence, which starts at internal page 558E, which is on page 999 of the hard copy, or 1005 of the electronic.
Right.
So if your lordships have that, the consideration starts at page 558G. It was common ground that a defence is open to a net payee in circumstances of this kind. It's not entirely clear what's meant by this kind. Obviously, the particular case was an issue, but it seems the wider point we're taking wasn't taken in Svenska. Now, 558G, if your lordships could please look at that. The principal issue is described by Clerk J as whether the net payee can rely upon events which occurred before the payment in support of its defence. And so at this stage of the judgment, and just pausing there, it is articulated as an issue about anticipatory versus consequential reliance. And given the way that issue is framed there, in my submission, one can see why the judge felt that this judgment had been overtaken by the recognition of anticipatory reliance. But as I'll show your lordship when we consider how Clerk J deals with the question later on, in my submission, his reasons for rejecting the change of position defence are more nuanced than that and aren't limited to the distinction between anticipatory and consequential reliance. So, looking ahead, please. Perhaps we could just go straight to Clerk J's conclusions, which are at page 565B, which is on page 1012 of the electronic bundle. And if I could perhaps
Sorry,
just,
paragraph what?
it's page 565B on the internal of the report. It should be page 1012 of the electronic bundle. It's the paragraph beginning, Mr. Mann submits that. If I could invite your lordships, please, just to read from paragraph beginning, Mr. Mann submits that, right down to page 565G.
Yeah.
So one sees in my submission that in these paragraphs an analogy is being drawn with estoppel, and Mr. Justice Clark accepted the submission that, as in an estoppel context, change of position defence can't arise where one is relying on an assumption as to the validity of a void ultra vires contract. And he refers there to the well-known ultra vires cases of Ryle and Matthews. And the key part of this reasoning is at page 565E, which your lordships have just read, and in particular the last sentence. Otherwise, the bank would in effect be relying upon the supposed validity of a void transaction. So that is the basis for the decision. And there are some further statements later on in the judgment which I need to show your lordships. First of all, at 565F, we see there the submission. The judge is considering a submission that Lipkin-Gorman is inconsistent with I can put it this way, a crude distinction between anticipatory reliance being impermissible and consequential reliance being permissible. And Clark J accepts that submission. So he's not basing, in my submission, his decision upon a straightforward distinction between anticipatory reliance and consequential reliance more generally. The reasons are wider. And then over the page, please, at 566 G and H.
Yeah.
Again, he's accepting here that in some circumstances, change of position based on anticipatory reliance may be available. But then at H, he's qualifying that by saying, however that may be as a matter of general principle, for the reasons which I've already given, there is in my judgment no justification for permitting the recipient to rely upon the understanding or supposition that a transaction is valid when it is in fact void. And then if I could please also draw your lordship's attention to 566J, and here the judge is addressing a submission that actually the logic of the judge's reasoning would apply equally to consequential reliance cases where one is dealing with a void contract. And the judge says he sees the force in that. But if I could characterise what he decides in this paragraph in this way, he's saying if the correct analysis is that even in a consequential change of position context, you are relying on the assumed validity of the void transaction, then in that context too, you shouldn't have a change of position offence. But that is over to dicta because that wasn't the position in Svenska. So if I could just summarise what we draw from this, my lords, we draw three things from this. First of all, as I've indicated, the issue was initially framed in terms of anticipatory versus consequential reliance. In my submission, that was not ultimately the basis of Mr Justice Clark's decision, and Mr Justice Clark was careful not to exclude anticipatory reliance as the basis for a change of position defence on certain facts. Secondly, the true basis for Mr Justice Clark's decision was, we submit, that relying on the assumed validity of a void transaction as a basis for a change of position defence would contravene the ultra vires principle, as articulated in the well-known estoppel cases of Ryle and Matthews, and that may render a change of position unavailable where it applies, whether or not based on anticipatory or consequential reliance. The second point. And the third is that we submit that rather than being overtaken by developments in the law of change of position, and in particular the distinction or the availability of a change of position defence in anticipatory change of reliance cases, we submit that those developments don't affect at the core of Mr Justice Clark's reasoning, and moreover, as I'll be submitting to your lordships, other developments, and in particular the principle of stultification, we submit reinforce that conclusion in the reasoning. If I please then turn to the authorities on stultification, and I should make clear up front, this is an area where there is limited jurisprudence, particularly at an appellate level, but we do submit that this is an important explanatory concept that will be of assistance to your lordships in considering ground 2A. And the context for this is the submission I made at the outset, that there is a principle of English law whereby a change of position defence is precluded, where allowing it would stultify the policy rationale giving rise to the restitutionary claim in the first place. The first authority I wanted to show your lordships on this is the FII judgment from 2014, which your lordships have at tab 58 of the authorities bundle, and should be page 3278 of the electronic bundle.
Which tab?
Tab 58. The part I wanted to show to your lordships begins at page 3200. My apologies, 3368, and that is paragraph 309 of this very long judgment.
Sorry, can you say the page number again, please?
Yes, my apologies, it should be 3368, well, 3366, the electronic.
Thank you very much.
And this is a judgment addressing, amongst other things, certain issues in the law of restitution as arises in Woolwich claims for restitution of unlawfully levied tax. And that is, of course, a different context, but it is nonetheless, we submit of interest for two reasons. First is that this is an area in which it is well established that a change of position defence is unavailable. So we submit it's illustrative to look at the reasons behind that, which, at least as Mr Justice Henderson articulates it, is stultification. And the second reason why we submit this is of interest is because it's an area in which a change of position defence is precluded, not in our submission as a result of the construction of any statute, but rather as a result of an analysis of the rationale for the availability of the restitutionary claim in the first place. And we submit that the operating principle for that, as articulated by Mr Justice Henderson, is the principle of stultification.
Yeah.
And so I don't need to show my lords much of this non-judgment, but your lordships will see above paragraph 309.
Hang on, I'm sorry, I'm looking in the wrong place.
Yes. Above paragraph 309, the heading, why is change of position not available in English law as a defence of Woolwich claims? And the background for this is in an earlier judgment, Mr Justice Henderson had considered that same issue, and he'd held there that the reason why a change of position defence was not available to the revenue as a defence to Woolwich claims was because of the wrongdoer exception. Now, I don't think I need to show your lordships this, but that he quotes from the relevant paragraphs of his earlier judgment, paragraph 299 of this judgment. And in these paragraphs, what Mr Justice Henderson does, he reconsiders that rationalisation.
That rationalisation couldn't be applicable here
The wrongdoer,
because this is a case in which
No.
the banks are innocent.
no, precisely. I don't say it is.
And this was a public policy reason. I mean, I can remember this case.
Yes. What we rely on this for,
I'm sure my lady can as well. Yeah.
yeah,
Okay.
but
Sorry. Yes.
well, our case obviously isn't a wrongdoer case, but we do submit that there is an interesting comparison or analogy between the reasons why a change of position defence is precluded in wrongdoer cases and also on stultification grounds. Because, of course, as your lordships will know, the wrongdoer exception, it's not about looking at relative fault in some abstract sense. We know from the Privy Council's decision in Dextra that relative fault isn't relevant to change of position. The wrongdoer exception applies where the wrongdoing arises in respect of the cause of action that is the basis for the restitutionary claim.
This is. I mean, I haven't read Professor Bant's article where she is apparently she's the person who comes up with the word stultification.
Yes.
But it's all in the context, isn't it, of the Woolwich claims in the first case. In other words, the rationale, the thinking was that the revenue couldn't rely on a change of position defence in circumstances where they wrongfully levied the tax in the first place.
Yes, and
That's the overriding policy that's being referred to in her article.
yes, precisely. And in his
But don't constat that it's an overriding policy in every case where, for example, somebody has acted ultra vires.
no, she's not addressing the ultra vires principle. What she's addressing is the stultification principle. But our submission is that the stultification principle applies in an ultra vires context. And so what is happening in these paragraphs, Mr Justice Henderson, he previously held in 2008 that the reason why you disallow a defence of change of position in Woolwich claims was because of the wrongdoer exception.
Yeah.
He's now reconsidering that, and he's holding these paragraphs, and maybe over to dicta, he's saying that the better rationalisation is the stultification principle. And if I could just invite your lordships to look at paragraph 311, where he quotes from Professor Bant's explanation of the stultification principle.
That's to do with not being permitted to keep the benefit of an unlawful demand. It's the same point.
Prohibiting unlawful demands.
The principle she's articulating is where it would stultify the policy reasons for ordering restitution.
Yes, but the policy reason for ordering restitution is the fact that there was an unlawful demand, and in essence, unlawful demands shouldn't be made.
And our submission, I'm of course not saying one can draw anything more from the Woolwich context, which is very different than simply that it's an example of the stultification principle at play. But our submission is that in this context, the underlying principle of the law is that effect shouldn't be given to ultra vires contracts, and it's that principle which we submit would be stultified.
That's a principle of, a general principle of English law.
Yes,
So it's not a specific public policy of Italian law to do with the reasons why Venice doesn't have capacity to enter into the contract.
No, my lord. The way we put it is as a principle of English law, and it's one which arises, and one is considering the coherence between restitutionary claims and restitutionary remedies in English law.
And you say it applies generally to ultra vires payments for public authorities or others as well?
Yes,
Because it could be ultra vires in a private.
I accept that, my lady. Obviously, our submission in this case is focused on the public authority context,
Right.
and in that context, we rely on dicta in local authorities cases,
Right.
which I refer to, which says the.
It must apply across the board. mustn't it?
But yes, but the logic of our submission, I think,
Logically, it would apply if a
extend.
company did something that was ultra vires.
yes,
If the director did something that was ultra vires, the same principle would apply.
yes.
Logically.
Because if the rationale for permitting a restitutionary claim in that context
Yeah.
is because the law shouldn't give effect to a transfer of benefits conferred ultra vires, then our submission is, in light of the stultification principle, one shouldn't allow a change of position defence because it would stultify the policy reason for permitting restitution in the first place. And I accept, of course, this is an authority in a different policy context, and I don't say that one can conclude from the Woolwich context, which raises distinct considerations, that an equivalently strong public policy factor is at play in the ultra vires context. But the principle I draw is simply the proposition of English law that one does need to consider whether allowing the change of position defence would stultify the policy reason for ordering restitution.
But hang on a moment. That seems to be what Professor Burrows is arguing as an advocate in paragraph 313. He submitted the charging of unlawful tax or ultra vires conduct by a public authority is not a tort or other civil wrong, but that restitution in those circumstances is for unjust enrichment. And the unjust factor in the Woolwich case is unlawful levying of tax. The implication being that the unjust
Yes.
factor in ultra vires cases would be that the parties that acted ultra vires or the local authority had acted ultra vires.
Yes.
But what Lord Mr Justice Henderson goes on to say, doesn't he, is really reiterating what he said in the first case. So he's not accepting the width of the principles as articulated by Professor Burrows.
So paragraph 315, my lord, on page 3,368.
316.
Paragraph 315, my apologies. He does there in my submission go on in that paragraph to accept that the wrongdoer rationalisation in the 2008 judgment wasn't the correct one, and in fact stultification is a better rationalisation the disallowal of change of position defences in Woolwich claims. And what he does there, if I may say so, is he draws together the academic analyses of Professor Burrows, which he refers to in paragraph 312, And although Professor Burrows in that paragraph doesn't use the language of stultification, he talks about a balancing between the weight of the unjust factor and the injustice in denying change of position. What he's doing, Mr Justice Henderson, I submit, is saying that both Professor Bant and Professor Burrows are saying the same thing, but using different language.
Where does he do that? Which paragraph?
So it's 312, so 311 he sets out Professor Bant's description.
Where does he go on to say, I prefer the stultification?
315. So perhaps just if I just read it. On balance, therefore, I acknowledge the force of the criticisms my reasoning made in FII 1 on this point, and I now think that a better explanation for the bar on the defence of change of position in Woolwich claims is to be found in the stultification principle advanced by Professor Bant and other scholars.
Yes, then he refers to the high principles of public policy.
Led to the recognition of the Woolwich cause of action as a separate one in English law of unjust enrichment, his own specific unjust factor. So I'm not sure it's right to say he's simply reformulating the same principle in a different way, but he's not going any wider, I don't think. At least I don't read him as going any wider. Didn't have to, did he?
No, my submission is simply that the not allowing a defence of change of position is rationalised in this authority on stultification grounds.
Right.
I'm not saying the public policy at play in Woolwich cases is similar to what we rely on here,
Okay.
but I do submit that the principle should apply. So that is FII. Could I please then turn to another authority on stultification? This is judgment of the Privy Council in SEB in Conway. Which your lordships have at tab 70, page 4449 of the authorities bundle. This was a case in which a common law defence of change of position was held to be unavailable in respect of a claim under a Cayman statute for reversal of an unlawful preference. And it's not a case in which the language of stultification is used, but we submit this as another illustration of the principle at play, but in a statutory context in which it's common ground the principle can apply. And in light of that different context, I don't propose to take your lordships through this judgment in detail. It's a very different statutory context. But I did want to refer your lordships to one or two statements of principle, which we submit are of assistance. If your lordships could please go to page 4087 of the electronic bundle. Paragraph 94.
Yeah.
So this is where the discussion of change of position begins. Paragraph 95, reference is made to Lord Gough's statement of the principle of law in Lipkin Gorman. And then I would just ask your lordships to read the sentence below the quotation Lord Gough was careful not to suggest. So there's an acknowledgement right from the outset of the development of the principle that it won't necessarily apply in every category of claim. And then I'd also invite your lordships to read paragraph 96. Counterpart of finding that it would be inequitable to require the defendant to repay the money which he received is that it would be inequitable for the plaintiff to pursue a claim for its recovery. And that, in my submission, is important because it requires one, I put it this way, one can't divorce the question of whether a change of position defence should arise from the question of whether it would be inequitable to permit the claimant from pursuing the claim. So one needs to consider the equity on both sides, and what we submit as one of the factors which goes into that analysis is the policy reason for requiring restitution in the first place. If I could then please take your lordships to paragraph 103, page 4089.
Yeah.
And there's, in the meantime, there's been a detailed analysis of, this is,
What is the detailed analysis of the insolvency?
there is elsewhere in the judgment a detailed analysis of the insolvency position, but in these paragraphs, paragraph 103 to 104, so the question is characterised as whether in the context of this claim, the common law gives priority to the operation of the statutory scheme of distribution, given the detrimental impact of recovery on the particular creditor, and then paragraph 104, the board answers that question yes, and then it's really the way in which the Privy Council is analysing this issue in paragraph 104, on which I place reliance, again in a very different context. But what I submit is going on here is that the Privy Council is analysing not in these paragraphs, although it's done that elsewhere, the specific statutory scheme, but it's analysing the significance placed by the common law on the underlying policy, the motivating policy. And that we submit is analogous to what we're inviting your lordships to do here, to look at the rationale for the ultra vires principle and how that marries up with allowing a change of position defence. So, my lord, I appreciate we're due to have a hard stop
Well,
at 4.
it depends on how, it depends on where you think you are. If you think that's a convenient moment to break,
I was about to turn to a new authority, so that may
It
be
might be sensible
a
if we
convenient moment.
might
And I'm,
be sensible if we stop there. I'm sorry
yes,
not to be able to sit. I've got a valedictory. I have to
I'm sorry,
attend
my
in,
confidence
so I have
that-
to go away.
I'm sorry, my confidence that I'd finish by 4 was misplaced, but I do need to.
No, we're not, we're not at risk, are we? Mr. Laney, this is more for you as well. +10 tomorrow? Can you
I
go
think
on?
that's fine, my lord.
Good, jolly good. All right. So, 10 tomorrow morning then.
I'm just being asked to hand up the transcript. I think my Lord Justice Mayles requested of Professor Alabrandi's.
We've got them, have we? Jolly good. Thank you very much.
Gorais?
Sending